Iowa is an equitable distribution state and an all property state, meaning that Iowa courts can consider and divide all property of either spouse in a divorce proceeding, including premarital property, gifts, and inheritances. The court is not limited to dividing only property acquired during the marriage. Iowa courts divide marital property equitably, considering factors including the length of the marriage, each spouse's contributions, the earning capacity of each spouse, and the economic circumstances of each party. Iowa does not consider marital fault in property division. For creditors, Iowa's all property approach means that the scope of divisible assets in a divorce, and thus the assets visible in divorce records, is broader than in states that limit division to marital era acquisitions. Iowa's homestead exemption is notably structured. Iowa provides an acreage-based homestead exemption rather than a dollar-based one. An urban homestead of up to half an acre and a rural homestead of up to 40 acres are exempt from forced sale. Importantly, there is no dollar cap. A home on a qualifying lot of any value is fully protected. This unlimited value exemption makes Iowa's homestead protection among the most powerful for qualifying properties. For creditors pursuing Iowa debtors with real estate, the key question is whether the property qualifies for the homestead exemption based on use and acreage, not value. Wage garnishment in Iowa. Iowa limits wage garnishment to the lesser of 25% of disposable earnings or the amount exceeding 40 times the federal minimum wage per week. Iowa's standard is slightly more protective of debtors than the federal formula in some income ranges. Iowa's necessaries doctrine. Iowa has a mutual obligation of support under which both spouses may have joint liability for necessary expenses incurred for the benefit of the family. People Locator. Skip Tracing provides Iowa debtor investigation and enforcement support. Visit peoplelocatorsskiptracing.com to place your order.